A long day, so I thought we'd try to get started on time. I'm Dr. Alan Kadish. I'm not a lawyer. I'm a cardiologist, but I'm president of Touro University. I'd like to welcome you to today's conference, which says it's entitled Academics, Lawyers, and Government: Who is Leading Higher Education in the 21st Century? One group not mentioned in the title is college presidents, although we do have our last panel, college presidents who are also lawyers. Last night, there was an introductory dinner where you heard from two of our distinguished keynote speakers, Louis Gard, Vice President and General Counsel, Bard and William Smith Colleges. He's also an adjunct professor of law at Cornell. Dr. Jacobson, the former president of Hobart and William Smith Colleges, currently a professor of economics. Today's symposium will delve deeper into the dynamic and changing realm of higher education. We grapple with unique legal, regulatory, and organizational challenges. It's no secret to any of you here, higher education is a highly regulated industry. And not only have the number of regulators and the extent of regulation increased, but as political changes happen in Washington or in states, regulations change. And in fact, in the past week, there have been repeated reissuances of guidance on a variety of higher education regulations. I don't think it's any secret that when the new administration takes over, many of the current regulations will look to be modified, some in positive, some in negative ways, depending on where you're sitting. So it's important for us to understand the political and legal influences, how we run higher education. As with everything that we do, a number of people have collaborated to make today's program possible. Elaine Langdon, who's Dean of Touro Law Center, Salkin, who wrote a great book that you should all have copies of about lawyers leading higher educational institutions. Nina Seplowitz, distinguished professor of law and the advisor to the Law Review. Roger Citron, associate dean for research. Anastasia Hagen, Associate Dean for Institutional Advancement. Jacqueline Zervuli, manages special events. Alexa Sunday, who's editor-in-chief of the Touro Law Review. This entire conference was put together by the Law Review students who seem to have segregated themselves to the left front of the room here. Welcome, all of you. And Gabby Rosenblum, special assistant to the provost, who did a lot of the grunt work here. There are 4 panels today, all great speakers, some from Touro and some from other institutions, and we're thrilled that all of you have joined us. Last panel will include college presidents, including Laura Demleitner, the president of St. John's College in Annapolis, Dr. Michelle Anderson, president of Brooklyn College, Andres Acebo, president of New Jersey City University, Dr. David Whipham, former president of Hamilton, and Dr. Laura Ann Rosenberry, president of Barnard. Thank all of you, both participants as well as attendees, taking time out of your busy schedule to join us today. I think it's going to be a provocative conference as we're buffeted by changes in every one of these fields and trying to figure out how to do the best job we can educating students in the face of rapidly shifting regulatory, government, and academic environments. Welcome. And so Dean Langdon.
Good morning, and thank you for being here. I echo Dr. Kadish's welcome, and we're pleased that you have joined us. As with every conference, there's always a group of individuals who are responsible, and we're very pleased that Provost Salkin is the one who really spearheaded this. I'd like to claim her as one of our own because, as many of you know, she is a former dean of Touro Law Center, and she still is a professor at the law school and continues to teach our students. The real heroes in this group, however, are our law review students, led by Alexa Sunday, who's our editor-in-chief this year. We're very proud of our law students who each year put on a wonderful conference. Last year, we dealt with the opioid crisis. Our law center was privileged to have been the site for the first opioid trial. It was during the pandemic, and we had the space. The courthouse didn't allow for social distancing. So our students were able to get a firsthand look as to the trial of a multi-district litigation involved 3 plaintiffs and 11 defendants. It was a wonderful trial experience for all of us in the building to be able to witness that. And as a result, we had a law review conference for that. The law review puts out 4 editions every year, requires a substantial amount of work from our students, who, as Dr. Kadish noted, have the front and center here. They come from all of our programs. We have a full-time All Start program. We also have a full-time January Start program. We just welcomed students to that program this week during their orientation. Our most recent time program we have is our Flex Time JD program. It is a unique program, unlike any in the country. It has in-person classes only on Sundays. And students then do asynchronous online work throughout the week in order to complete their education within 4 years. The beauty of this program is that it allows individuals who could not go to law school because they wouldn't be able to take off of work, but childcare responsibilities, whatever their responsibilities are during the week, would not be able to give those up. On a weekend, can carve out that one day in order to be able to take classes and earn their law degree. See a lot of those who are underrepresented among lawyers who participate in that program. And all of those students, our full-time and our JD students, all participate on law review. The law review has done a wonderful job making sure that everyone has a place on the law review and are able to participate regardless of what program are involved in. So before we get started with the program, I do want to acknowledge our sponsor. And we have some wonderful sponsors who have generously donated to support the program. Our lead sponsor is Nixon Peabody, and they were joined by Cozen O'Connor, Kenner and Block, Troutman Pepper, Higher Education Consolidation Solutions, and Thompson Coburn. Without them, we would not have been able to have the dinner last night and a lot of the refreshments for today. So we're very pleased that they have joined with us. We're going to hear a little bit more about the program next from our Associate Dean for Research and Scholarship, Roger Citron, who also works with the Law Review. Roger?
Thank you, Dean Langen. Thank you, President Kadish. Very quickly, I just wanted to talk a little bit about a broader perspective. The conference means lawyers, law students, and of course, all of you who have a connection in some way to higher education. For me, the story with the conference goes back to the summer of 2022. That's when Provost Salkin just about done with her book, May It Please the Campus, and that, of course, copies are available. All of you, it is a marvelous book. It's a shout out not only for the book, but it's also specifically directed all of you economists out there. I know there are some of you, we talked about that last night at dinner, did a podcast, a Touro Law Review podcast with Provost Salkin about the book. So, of course, in reading the book, preparing for the podcast, what really impressed me was the comprehensive data set in the book. There's, of course, narrative, context, explanation, and there's all of that. But really, when I was done reading the book and after we had talked for the podcast, I gave the highest compliment you can give in an academic context, which is you've really advanced the ball here. I mean that seriously and sincerely. Of course, last night, our two speakers sort of complimented, picked up where Provost Salkin left off. Their book, also available last night, I thought was a wonderful introductory discussion and presentation to set the stage for the conference today. And then the last thing I wanted to say, along with, of course, the thank yous to our sponsors and to everyone involved in organizing the conference and to all of you for coming here today, is that I'm about to start teaching administrative law next week in the spring semester, and I know that. And we all know the administrative law story. You start with the New Deal and the first wave of agencies like the Securities and Exchange Commission, and then of course, story picks up significantly in the 1960s and early 1970s with a different set of agencies like the Environmental Protection Agency. We're now in a third wave of administrative law. And there are many different factors contributing to that third wave. Absolutely, higher education, the developments that we're going to talk about today, is part of that third wave. That is to say, there's this intersection, I hope it's not a collision, between the administrative state, administrative law, regulation, and the industry, as was said last night, of higher education in the sense of how things are done in universities, colleges, in higher education campuses. With that, thank you all for being here, and the first panelist should please come up.
Welcome to the first session of the conference, Changing Regulatory Landscape in Higher Education. My name is Elaine Crosson, and I have over 20 years experience in higher ed. It's working? Okay. I served as general counsel at Fordham University, Long Island University, and I was VP for external relations at Stony Brook University. And I'd like to introduce my panelists. It's a great group with a lot of experience in higher ed. To the far right is Stephen Richard, and that's only where he's seated today. That's not a political statement. He's a partner at Nixon Peabody. He has over 30 years trial and appellate experience. He's one of the firm's national leader in Title IX and higher ed teams. And he's represented colleges and universities in many Title IX cases. Seated to Stephen's left is Matthew Lieberman, and he has over 12 years experience. Currently serving as the Associate General Counsel at Touro. He's the Director of Regulatory Compliance and has particular focus on financial aid and Title IX. So welcome to Matthew, and thanks for having us here. Seated right next to me is Brian Kim. He's currently GC at San Francisco Bay University. He's got a 40-year legal career, 13 years in higher education. Brian focuses on accreditation, particularly of osteopathic medical schools, and the regulation of graduate medical education and post-residency practice. And joining us by Zoom from sunny Florida is Professor Peter Lake. Peter is the Charles A. Dana Chair and Director of the Center for Excellence in Higher Ed, Law and Policy at Stetson University, College of Law. Prior to joining the Stetson faculty in 1990, Peter practiced law here in New York City, Cahill Gordon. Peter is an internationally recognized expert in higher ed law and policy. So that's the panel. We have about 90 minutes to discuss this very broad subject of the changing landscape, of regulatory landscape. We've set this up as a roundtable discussion. We'll set aside some time at the end for questions. And before we start our discussion, I just want to get a sense of the audience. How many are in-house counsel to a university? Okay. How many are outside counsel to a university? Okay. How many are students? Welcome, and you'll learn today that maybe you should go into the practice of higher ed law. How many are administrators or faculty? Okay. Yeah. So this is all about how to appreciate your general counsel. As has already been stated many times since we've been here, higher education is a highly regulated sector. According to NACUA's Compliance Alliance, an organization that I just loved the name, the Compliance Alliance, they put together a chart every year, they update it. And the last time I looked at the chart on the train up here, they listed on their matrix 296 federal laws and regulations that higher ed has to comply with. That's 296 deadlines, changing regulations, all kinds of guidance coming out, a lot to and those regulations cover everything from student financial aid to student affairs to academic programming. I had experience in front of the EPA because there are hazardous waste chemicals on campuses. I spent some time getting to know some folks at the IRS over governance matters. So it's a wide array of areas that we're regulated. So we're going to focus today on really not only two major changes in this landscape. One is obviously the shift in administrations from the Biden administration to the Trump administration and a Republican Congress. The other area that we're going to focus on is a dramatic change in administrative law in a decision that was rendered by the Supreme Court in June of 2024 called Loper Bright Enterprises versus Raimondo, which really overturned about 40 years of precedents in how you challenge the rules for challenging an administrative regulation. So with that, I'm going to turn to Peter. Hi, Peter.
Hi,
Don't
Elaine.
tell us how warm it is in Florida, please. But Peter's going to give us an and some of the ramifications that we may feel in higher education. Peter?
Thank you, Elaine. And I hope I'm coming in loud and clear. You'd be pleased to know, Elaine, that the weather here is actually a little on the cold and dreary side today for Florida. I think you all have sent some of the icy weather south to us. So, of course, it's probably noticeably warmer than it is up there. Hey, before I get started, I just wanted to do a shout out to Touro for hosting this, and great appreciation to my longtime friend, Patricia Salkin, and her fantastic book. And Elaine, thank you for everything you did to put this particular panel together. I certainly appreciate that as well. So in many ways, I come from the ancient past. I've been doing this work now since the 1990s. And when we spoke of a third wave, it really triggered a thought for me to open up this morning that I remember a time in higher education before what I've been calling Compliance U landed, when compliance issues were not really as prominent in the higher education legal discussion as they have become. In fact, if people in the room go back a long ways, you'll remember that the principal topics for discussion prior to 2008 or 2011 were typically FERPA and the Clery Act, trying to comply with that. I remember Leroy Rooker would visit with campuses to talk about FERPA compliance and try to put people at ease. And a charming, wonderful fellow, tried to put people at ease. I think often people were less at ease when he left, and it sparked the need for a yearly update from the Department of Ed on FERPA. It all seems kind of quaint. And then the recession came. The Obama administration came in, and I remember distinctly in February of 2011, I put together a conference, my national conference, and I had a panel on the coming federal regulatory juggernaut. And a lot of people afterwards said to me, what are you talking about? This is, sky is falling. You're overreacting to this. And it was, just a couple months later in April that we got the Dear Colleague letter that in many ways was the Bunker Hill of federal regulation of higher education and set off, I think, what I called Compliance U. And this would be the second wave of our regulatory state. And now, Elaine, as you mentioned, the summer of 24 was a pretty remarkable moment because we get the regulatory trinity of Loper Bright, Corner Post, and SEC versus Jarsky. And really, as a triad, they rewrite many of the foundations of administrative law that will impact higher education and certainly well beyond. It's interesting. I'd had Judge Ken Starr, when he was still alive, visit my conference back in 2019. And he had predicted that Chevron was on the table, especially with some of the new appointments to the Supreme Court, including Brett Kavanaugh. Folks were having a little trouble hearing that message because he was, of course, embroiled in a Title IX controversy at Baylor that sort of dominated discussion. But I heard that loud and clear. And so I was more prepared for the Loper Bright decision, I think, over the years than some folks have been. Loper Bright is fascinating because I barely have practiced law in a period in the pre-Chevron time. I entered practice in the 1980s. And when you look around practicing attorneys, there are often a lot of folks who have no experience in the pre-Chevron period. So this is really tabula rasa for a lot of folks trying to figure out what will be next when the Supreme Court takes the position that they have the final say on interpreting statutory breadth and depth and regulatory reach. We'll certainly have to see what that means. But you have to really put Loper Bright in context with Corner Post and SEC. Corner Post, of course, setting up the possibility for challenges to regulations that have been longstanding, setting an accrual standard of harm that essentially opens up any federal regulation to potential challenge. Certainly the dissent in that case pointed that out. We shall see. And the SEC case, which is a companion, which has told the Federal Reserve and others that if they're doing something that looks like a common law trial, they have to provide rights to trial by jury. And Elaine, I may have some thoughts about that as we transition out of this panel to the next one for purposes of Title VI. I have some thoughts that perhaps we'll revisit at that time if that works for everyone else. Compliance U is not over. It's just pivoting. And although there is, I think, the potential for certain levels of deregulation that may come, particularly with the new administration, I think what we're seeing is a shift to management by judiciary. And I use that term deliberately because I remember years ago reading a famous book by Raoul Berger called Government by Judiciary. It's a broader theme. It's fascinating how the politics of this have shifted almost 180 degrees in terms of emphasis. But there's no question that we're entering a time where regulation and compliance in higher education is going to be dominated more by analysis of what judges are saying and doing and what they're not doing. My prediction is things are going to get more complicated and more legalistic. And one of the challenges for someone like myself who does a lot of consulting and legal work is trying to translate high administrative law discourse into meaningful boots on the ground campus action. And it certainly has not been getting any easier. I think it's likely to even get more complicated as people will be required to decipher complex judicial rhetoric, complex concepts of administrative law. I don't necessarily see a future where we have a seamless or even consistent regulatory landscape. I'll talk a little bit more about that. I think uncertainty and seamlessness may be a big part of the regulatory structure because, again, as judges here and there make various decisions, it may be difficult to reconcile one jurisdiction's perspective to another. And of course, we've already seen that sort of thing in the non-regulatory world. For example, if you're familiar with legal cases on bias response teams, We have a split in the circuits over that, and even the Supreme Court justice has pointed out that that level of uncertainty is problematic for higher education and beyond. I do think a lot of regulations will survive. I don't think this is the sky is falling. I think we're going to see some regulations pass muster with various judicial authorities all the way up to the Supreme Court. And I'm wondering if what we may be entering is a time where we have what I'll think of as super regulations, regulations that have been vetted by the judiciary in a way that they become almost untouchable or even potentially unchangeable because the judiciary has vetted them and approved of them. It's certainly going to change the way I think regulators approach changing regulations. They're going to have to think really and I think they do in a large measure already do this, think that they're developing briefs and cases that will come down the road challenging the legality of any regulatory structure that's been created. I've been telling people that the law is the law until it's not. And I know particularly I do a lot of work in the Title IX sphere, and I don't want to jump ahead on the panelists here, but immediately I've been pointing out to folks that the 2020 regulations are the law until they're not in Title IX. More than ever, I think it's incumbent on lawyers and leaders in the field to try to decipher the winds of change, not just anticipate specific litigation, but what could be in the wind in terms of challenges that may come to various regulations. And I think, Elaine, this panel and the panels that follow will take us in greater detail and depth on what some of those wins might look like. The focus has definitely shifted to your local federal court. And again, I've gotten familiar with this dynamic doing a lot of Title IX work, but more than ever, your local federal judiciary is in many ways a manager. And this, of course, will be at the district level, circuit level. I think that in many ways, Loper-Bright may have created a very challenging judicial environment for the federal judiciary. There's really no way that the Supreme Court could lift all of the issues that Loper-Bright, corner post, et cetera, might create. And so we're looking at a lot of emphasis on which circuit you're in, and particularly your local federal district judges and what they are thinking and interpreting particular laws and rules may look like. Again, not to anticipate, but we've actually had this phenomenon just take place very recently with Title IX, and I know the panelists will be talking about that. I have some concerns about competency of the federal judiciary to essentially arrogate so much authority to themselves as regulators. This will be a constant source of debate, I think, as we go forward, are we moving essentially regulatory power in the hands of judges who don't have the expertise necessarily in a particular area or field, away from people who may have greater expertise. The lack of trust in federal regulators that the judiciary is sort of indicating with Loper-Bright, I think it may get projected at the federal judiciary as well. And I'll give you an example. And Elaine, I know you had asked me to share case names ahead of time, and I'm doing something that you'll probably never forgive me for, but I'll draw attention to a case in the First Circuit called Hydeck against the University of Massachusetts Amherst. Justice Souter, retired, sat on the panel with my former boss, Judge Selya, formerly of the First Circuit, and they considered due process issues that came up in a suspension and expulsion. And in the process of discussing whether or not the institution had complied with due process, the judges alluded to the fact that what the hearing panel had done with evidence was consistent with federal rules of evidence. And, from their perspective, that would mean it was good enough to pass muster for due process purposes. Well, I don't know that they really fully thought through what they had just done with that ruling, because the message that campuses get from a ruling like that is pull out the federal rules of evidence and use them to guide you in decision-making with respect to hearing decisions, and particularly ones relating to evidence. Now, for those of you that are very Title IX savvy you'll remember that the 2020 amendments in the preamble talk about essentially not using the federal rules of evidence in a lot of ways. And I think this creates the kind of confusion on campus that I think is likely to become more endemic as we move forward with local right. I think the states are going to fill the gap. I think what you're going to see is if the federal regulatory system reaches more of a standstill or more challenges, there'll be more pressure to regulate at the state level. This is a trend that we have clearly seen accelerate, particularly since the Biden administration, but really even before that. And I think we're going to see an interesting markup or markup, mashup, however you want to say it, of red, blue, and purple state regulation, raising a different set of issues that move us away from Loper-Bright, but could raise some interesting federalism issues. Theoretically, Congress could overrule the corner post case. They have the ability to do that. I don't know if there's going to be the will or interest to do such a thing. I think the accrual issue may eventually raise its head enough that Congress might consider revisiting the statute that underlies the corner post case. Loper-Bright seems almost unfixable. I simply can't imagine, and I'll be curious if anyone on the panel thinks this is a possibility, that Congress would pass the Chevron Restoration Act or something similar. I just don't. And even if they did, there's enough energy on the Supreme Court to suggest that that could be unconstitutional to do that. And so I don't see the will of Congress to do this or really the positive outcome to change it. And that means that, we're here with Loper-Bright for generations potentially, that this is not something that's necessarily going to fade away into the past.
Peter, on that note, one way I think to get around a Loper-Bright challenge to a regulation would be if Congress were more specific in the underlying statute. And I guess one of my questions is, how likely do we think that might become, particularly it may be easier with a Republican Congress, and a Republican president. But how likely, is it that Congress is going to write clearer statutes?
Elaine, you took my next talking point.
Oh, sorry.
No, it's perfect preparation. This is like pass and shoot. I love it. So if only the Knicks played like this, right? Had to throw that in there. So here's the thing. It's in a theoretical world, Congress could just simply be more specific and authority granting in the way they write statutes. Frankly, we've been seeing Congress in the recent times to be very gridlocked. I don't know that that's going to see a lot of change. And I've never had a lot of faith in draftsmanship on a broad level for bills. In other words, to get to the level of specificity. And the truth is, even if you are specific, it still launches the issue in the hands of judges who can play around with semantics and words in a way that may turn Congress on its head. Congress may think we were very clear on this and we were not. I do think what we're likely to see, Elaine, is something that's brewing in Congress right now. Is you'll notice that Congress is toying with the idea of banning transgender athlete participation. And that would be a potential modification of Title IX, or depending on how you see it. And again, I don't want to get too detailed with this, but I could see Congress coming in with very specific tinker points that might garner a majority across the aisles. But one of the larger themes that this conference, and I think all conferences really on administrative law have to deal with, is we may be moving to a broader period where you're seeing radical pivots in federal administration at the executive level in terms of goals and outcomes, and a Congress that is very gridlocked, putting a lot more emphasis on the judiciary in terms of managing a constitutional democracy. We shall see where that goes. I know some people have talked about the Supreme Court as an imperial Supreme Court. I'm not taking a position on that, but I'm aware of that sort of moniker that's been applied. And Elaine, that kind of leads to my next thought, and I am nearing the end of my remarks, so don't worry, I don't plan to sit here and blow all the wind out of this particular panel. I am watching the status of Marbury and Madison. I mean, when you read Loper and Bright, this is where it starts. It's, you know, a discussion of the authority of the federal judiciary, particularly the Supreme Court. And I wonder if federal executive administrations will accept limitations on their authority that will come with the delays that are associated with litigation and the potential countermanding of various objectives. I wonder if we're headed towards a constitutional dialogue that's been brewing for a couple hundred years, and maybe it will come to a head. Will it come to a head in the college world? Well, to some extent, it theoretically could. One of the things that's been notable to me, Elaine, is that higher education has moved dramatically up in the national political dialogue. We're not just highly regulated, we're highly visible. And
Yes.
sometimes I, having been affectionate to Harry Potter, I wonder if we're seeing a little bit of the Ministry of Magic start to show up, that Hogwarts, once invisible to the Muggles, is now very much in everyone's mind. And that tells me that we could well be looking at a constitutional challenge that actually relates to a higher education issue, something I couldn't have imagined saying to a group even
Right.
10 years ago.
Right.
You know, Lane, a couple other thoughts just as I pivot out, but I think one of the big ones is the change in legal services and the change of legalistic services on campuses.
Yes.
You know, the trend that I've observed over the last 30 years, unmistakably, is increasing legalization of the field. And this particular pivot, I think, requires skill sets and training at an even deeper level than we've seen in the past. Some of us who have gone through Title IX regulatory compliance work, you realize just how deeply you have to dig into the world of administrative law. Frankly, a level of administrative law that I wasn't taught in law school. I had to learn in practice, boots on the ground. I think it's getting more complicated, and I think your list of sponsors is a perfect example of the kind of specialized services that people absolutely need to navigate compliance shall we say, third wave, I think, to follow the theme from earlier. And the other thing that's happening, and I suppose I should be the last person to complain about it, is more and more people with legal training are taking the jobs of people who were once trained as educators. Law is not just regulating higher education, it's occupying the field. And I want to sort of throw this sobering thought out that something interesting happens when an industry goes from being the regulators to actually becoming the people who compete inside the industry. My center routinely places my students in what they call JD Advantage jobs or non-law practice jobs that were once held by people with MEDs, EDDs, and PhDs. And I wonder if people will start to pick up this trend and realize that higher ed is actually now not just regulated by lawyers, but actually competing to some extent for jobs. It's a change in culture, and it's a much broader conversation, but I think it's likely to accelerate in the face of Loper Bright because of the need for really technical understanding and the ability to try to read the winds of change in complex court cases and the change in the judiciary. You know,
Thank you, Peter. You know, when I read Loper Bright, I thought, oh, full employment for lawyers.
Yeah.
You know, and particularly in the higher ed space.
Yeah, Elaine, I've joked that Title IX was the Lawyers Relief Act.
Yes.
Yeah,
Right.
because it brought an awful lot of jobs to people, particularly jobs that could pay off loans. It could go public service work, very attractive alternative careers for people who wanting to practice law per se. And I just think it's becoming less and less likely that you can do higher management and higher education without some legal training and exposure, which is a trend that some of the authors have talked about. Is leadership is now starting to pivot towards legally trained people, and we're
Yes.
a trend I think that is on the way. You know,
Peter, we're going to circle back to you towards the end of this discussion. So I wanted to throw it over to Stephen right now, if I could. We're going to be talking about Title IX. So I wanted you to stay tuned and jump in as you see fit as Stephen goes through. He's going to give us a little bit of a history of Title IX and then tell us what it's been like in the trenches as the pendulum has swung back and forth from administration to administration. And I just want to say that when I first started in higher education, when there was a claim of sexual assault on the campus, we called the local police and the district attorney's office took over. We've come a long way since that time. And so now I'm going to turn it over to Stephen, who can share his war stories with us.
Good morning, everyone. Can you hear me okay? Yeah. My name's Steve Richard. I'm a partner in Nixon Peabody. I lead our higher ed practice, and I'm going to talk today about Title IX. We have 22 minutes to take you through a statute that was enacted 53 years ago. The amazing thing about Title IX, it's codified at 20 U.S.C. 1681A primarily, 37 words. Of all that Peter said and all I'm about to tell you, 37 words. That is the foundation of the law that has exploded, not only administratively, but I really have to build on what Peter said. It's in the trenches. It's in the courtrooms. It's at the district court level. At state court levels, sometimes when you're dealing with contract claims and not Title IX, attorneys are getting a little savvy now and trying to bring you into state court if they don't like a particular federal judge. But it really is exactly what Peter said. It's trench warfare. And I've had judges tell me when I cite the local rules, Mr. Richard, it's not what the local rules say. It's what the local ruler says. That's just the reality. I get called into court sometimes on injunction hearings with a respondent accused of sexual assault who has been suspended, expelled, or facing that consequence and doesn't like the way the process is going. The judge calls me in an injunction. I said, Your Honor, let this run its course. And that's not an easy argument to make. And I'm going to build off some of the basics of Title IX in a minute, but what Peter really said is the reality of what we have to deal with and how this law develops in the courts. You know, we talk about the Haydick decision that Peter mentioned. Applies to public institutions. I represent a lot of private institutions. Judges will look at me and say, Mr. Richard, how is this due process? I'll say, well, Your Honor, we're a private institution. We're not subject to the Constitution. Due process is not a term that applies here per se. You can guess how far that goes.
Yeah.
So the reality is we really have to deal with the intersection as lawyers representing higher education institutions, the administrative state, Department of Education regulations, what the judges do, the realities that go on every day at campuses. I intersect daily with offices of general counsel who are overburdened, overstaffed. We have people in the process, Title IX coordinators who are burnt out. We have deans dealing with things on the ground, phone calls coming in the middle of the night. They have schools where the panels include students citing sexual misconduct cases. And that's often a difficult sell in court to explain that. But what we deal with here is really two avenues, the administrative requirements and the judicial interpretations that sometimes run parallel, but a lot of times intersect in ways that create a lot of problems for us trying to advise our clients in higher education. You know, every day when I step into the office, the first thing I do is two things. Go onto Lexis or Westlaw, type in title. Also a proud NACUA member, and I see our president here. And I go on daily to see what my colleagues are facing and what they are encountering in their jurisdictions. It is a vexing challenge every day. Title IX initially, for the longest time, dealt with athletics. That was the foundational aspect of it, gender equity. And the courts including First Circuit cases where I practiced, Cohen v. Brown University, grappled with how do we equate equal opportunities and benefits and sports programs, et cetera, for female athletes. And there's been tremendous laudable successes that we've seen watching the Olympics every 4 years. But it dramatically transformed over time. And the Supreme Court, over time, recognized an implied cause of action under Title IX. Understand Title IX, as codified, only allows expressly for administrative enforcement. It's a spending clause statute. It's a contract that the federal government and funding colleges and universities enacts, essentially, to say, we will fund you as long as you. And over time, the Department of Education had regulations that were relatively dormant by it going back to 1975. The administrative state really exploded in my world in Title IX on a date that Peter mentioned. There are 5 dates I remember in my life. Birthday, my wife's birthday, my son's birthday, most of all, my wedding anniversary, April 4th, 2011. What was that day? The Obama administration, through the Office for Civil Rights within the Department of Education, issued an 18-page single-space letter captioned, "Dear Colleague." Is not a regulation, was not promulgated through a regulatory comment process. It was a guidance document issued by the Department of Education's Office for Civil Rights that said, this is our set of expectations as to how you administer sexual harassment issues on your campus and as a condition of our funding. What was the problem? It went in directions that were not entirely consistent with Supreme Court interpretations. Supreme Court really has set the foundation in sexual harassment through 2 decisions that date back a quarter of a century: Webster v. Lago Vista School District, faculty on student alleged harassment, and Davis v. Monroe County Board of Education, 1999, peer harassment, student on student. And generally, there has to be a showing of actual knowledge. There has to be a showing of deprivation of access to programs and activities. There has to be a level of severity, pervasiveness, and objectively offensive conduct. But most importantly, there has to be notice in a deliberately indifferent response, because the school itself has to intentionally discriminate. So deliberate indifference is the benchmark standard that's been equated over time by the court. So we've had these 2 cases from 25 years ago, setting a foundation about how courts should look at sexual harassment issues. The Dear Colleague letter that came forward in 2011, it said, well, maybe not actual notice. How about constructive notice? Yeah. Maybe not severe, pervasive, and objectively offensive. Let's make those disjunctive. And it also set forth a lot of expectations and realities that schools grappled with implementing. What we saw, frankly, was a pendulum where respondents, a few students, felt like they were not getting fair shake. Now, I sometimes have to go in and defend that fair shake. And sometimes I do think that schools are put in a catch-22 process. The first thing I always stand up and tell a judge is, Your Honor, perfection is not the standard. The question is, have we discriminated on the basis of gender? Have we somehow run amiss? Have we breached the contractual requirement? What we saw in 2011 was the Obama administration beginning a trend of administrative activism. There were subsequent guidance documents, a question and answer document that was issued in April 2014, 50-something pages, more delineation of guidance, not regulations. And we're going through a process where judges are starting to intersect. You know, Peter mentioned the Haydick decision and other decisions like that, where judges started to intercede and say, this just isn't fair. And I don't think I can let this stand no matter what the Department of Education says you should or should not be doing. And what we saw is a change in administrations. The Trump administration wins the first time in 2016, and immediately in September 2017, rescinds the Obama guidance documents. So now those are gone, and the Trump administration tells us to look back at prior guidance documents dating back to 2001 and late 1990s. says, hold tight, we're going to issue our own set of regulations. We're not going to issue a guidance document. We're going to go through an extensive notice and comment period. And that's what happened. Ultimately, the Trump administration, for the first time in the history of the Department of Education, enacted Title IX amendments in 2020 that were specific to sexual harassment issues on campus. And what was significant about that was twofold. Number one, it was a regulatory process. You had rules now that are entrenched and codified in 34 CFR Part 106, and you have delineated expectations that are now more formalized, administrative documents that also significantly coincided and were more consistent with Supreme Court precedent. And I mentioned those two cases up front, Gebser and Davis, that date back to the late 1990s. Well, the Trump administration tried to parallel those decisions as much as it can, particularly Davis, and defined sexual harassment entirely consistent with the Davis standard. But at least you had some synergy, not total synergy, but some synergy between what was going on administratively and what was going on through judicial precedent. You know, one of the things that has fascinated me as a Title IX lawyer and litigator is that the Supreme Court has been really reluctant to revisit its precedents going back 25 years. Davis and Gebser foundationally give me the elements, but one of the prerequisites is that it has to occur within an education program or activity. Schools cannot guarantee conduct everywhere in the world, but the question is, what is your education program or activity in this era? So going back to that time frame, late 90s, I'm old enough to remember fax machines. I know some law students may say, what's this guy talking about? But we now have the reality of social media. And, you know, there's a case out of the First Circuit, feminist majority v. Hurley, which dealt with yik-yak harassment.
Oh, right.
In a very limited radius around campus, but it did permeate off campus. The question of where does the boundary of substantial control lie? It's just not geographically, because you can be responsible as a college or university for sexual harassment outside of your campus boundaries. To what extent should we hold schools responsible? And there have been splits within the circuit, as Peter mentioned. Judges have their own interpretations. Judges have their own political philosophies. And we have routinely watched, will the Supreme Court revisit these precedents? And every time I think there's a case that has the split, look at the orders list, cert denied. Okay, so we have this foundation that is pretty well set with Davis and Gebser as to the elements. We have the administrative state in 2020 that at least somewhat coincided. Then President Biden gets elected and substantially transformed the administrative state through regulations. He did not go back to a guidance document. It was a notice and comment period that was coinciding with the 50th anniversary of Title IX. And the regulations substantially expanded what the Trump administration had put in place. The definitional boundaries were substantially greater. The protections now included gender identity, sexual orientation, pregnancy-related conditions. The definitional scope of sexual harassment and away from Davis and went back to what we saw in the Obama era of severe or pervasive. And the question became, what process is due? Trump administration implemented a very regimented grievance process in its 2020 regulations. You had to essentially go through a notice process, investigations had to ensue, a sharing of evidence. There would be a hearing with cross-examination, and cross-examination is a huge issue in sexual misconduct cases, particularly in jurisdictions that are subject to, colleges and universities that are subject to the Constitution. It's a matter of due process, such as the Hayda Court in the First Circuit, O.V. Baum, which is the University of Michigan case on the Sixth Circuit, deal with to what extent should, as a matter of due process, never mind Title IX, public university guarantee opportunity to be heard and an opportunity to confront witnesses. So the Trump administration had put in this regimented policy and procedure grievance process It required essentially sharing of information, investigations, hearings before a live hearing panel with the right to cross-examine witnesses. And all throughout that process, there had to be independent decision. Biden administration's 2024 regs, in a nutshell, undid a lot of it, left a lot of discretion to schools as to whether they would keep those types of formal hearings in place, whether they would continue to allow cross-examination. And so what we immediately saw, and what you've probably read about, what I really want to address now, is where do we stand? After all of that ensued, regulations take effect after public comment, the red states took action, okay? And there was a plethora of lawsuits filed challenging the 2024 regulations. The result were several injunctions that enjoined the enforcement of Title IX, 2024 regulations. So what we had up until a week ago was the situation where 26 states were enjoined from following the new 2024 regulations. 24 states, including some of my clients, had to adapt to the 2024 regulations. And then there was another ruling that said, well, there's a list of schools, 50 or 60 or so, that have associational relationships with some of these plaintiffs. We're going to enjoin them too. So it became a smorgasbord of Title IX compliance at the administrative level. And what happened last week, and I think something building on where we're going, a court in Kentucky issued a bombshell. Sitting at my desk and the phone starts ringing, and the judge in Kentucky federal district judge, he previously enjoined the enforcement of the 2024 regulations in the case brought before him and the 5 or 6 red states. And he said, I have a couple of problems fundamentally with these regulations that I am going to dispositively address. Number one, he said that the Department of Education went beyond its authority. Now remember, Title IX statutorily says expressly administrative enforcement. And what the judge said is, yes, you have that power, not to the extent you exercised it. And the fundamental issue that started that decision was the question of how do you define sex? Remember what I said at the outset, those 37 words? Included within them is no person in the United States shall, on the basis of sex. What does sex mean? Is it biological or is it something else? And we have the Supreme Court's decision in Bostock, the Title VII context, that expanded definition, at least for Title VII purposes, beyond biological interpretations. Now, that case was very limited. There's caveat dicta in it saying we're not going into the area of transgender bathrooms. We're not touching anything like that. Justice Alito wrote an 80-page dissent listing every statute that he thought would be implicated by this in a bad way, including Title IX. So this judge and the judges that were enjoining the new regulations said Bostock doesn't apply. But there are judges who have applied Bostock in the Title IX realm to issues of bathroom access and other interpretations. So as Peter says, it's really the jurisdiction where you stand, as you stand before, that calls the ultimate legal determination. And so what the judge said is, first, that's the problem. You've gone beyond the boundaries of authority and how you interpret sex. Second, I see a constitutional problem. What you have done is essentially compelled people to recognize gender identities that they may not believe in and fundamentally can recognize. Pronoun usage. The judge said you could compel someone to use a pronoun that they think is improper. That implicates a First Amendment concern. That is a constitutional quagmire that I think further undermines these regulations. The third aspect of it was he said these are just so arbitrarily and capriciously enacted and enforced that no one knows what they're supposed to do. With that foundation, the Kentucky judge said, here's what I'm going to do. I'm just not going to issue a permanent injunction to decide this case. I am going to vacate the 2024 regulations in their entirety. That's what he did. And, you know, the text messages started, the phone calls started. And the reason it's important is, as Peter said, we'll go back to the 2020 regs. What about a case that's ongoing now? I have clients that are in the middle of process that we started under the 2024 regs. They're calling me up daily saying, Stephen, what do we do now? Because these are illegal. We're so far along. We have to go back and start. And oh, by the way, a new president's coming in on Monday with a new Department of Education head. What's going to happen? So we're all in a state of anxiety. We're all in a state of flux, but we are trying our best to figure it out. And foundationally, what I am telling clients is you have to default back to the 2020 regs. You have to await to see what will happen. If you proceed forward on the 2024 regs, you are proceeding at your own peril. But what will happen very soon is we will get to the forum that Peter mentioned. There will be legal challenges. The legal challenges is just not fundamentally, are these regulations proper? How are they being applied on a daily basis? That's where I spend most of my time. What do I see in court? It's a difficult reality because you have highly, highly emotional stakes in these cases. Well, a judge in my jurisdiction, as I tried before him, with a bench decision and said something that resonates with me. Said, the bottom line is these are extremely, extremely messy cases. You have complainants who have been victimized, complainants who want redress and accountability, who have respondents who either say it didn't happen that way or I'm being railroaded. And what do you do to balance the playing field? One of the realities I see that's often a challenge for me is I'm the guy in the middle representing the institution, trying to defend a process. The process of policies and procedures. Those policies and procedures certainly implicate Title IX. It can, at a public university, implement constitutional issues, Section 1983 issues, but also on a basic level, they implicate contract issues. A policy that a school has with a student, such as a sexual misconduct policy, is a contract. So this is a dynamic area of the law where daily we are going forward, trying to chart the proper course. And where it is most challenging is not my job, it's on the ground with the deans, the administrators, the Title IX coordinators. We're trying to administer a process. And we talked about the legalization of higher ed. We do see more lawyers in the process. We also have a lot of non-lawyers in the process. And how do they define preponderance of the evidence? If that's the standard we're going to be clear and convincing, it's maybe the standard in the future. So this is a dynamic example of essentially trench warfare. And the overriding issue is here. We want it to be fair and equitable. That's what it's supposed to be. That's the challenge.
Thank you. That was a wonderful overview. And I just want to say, if the overall arching message here is love your general counsel's office, I think you also have to love your Title IX coordinator and understand why their hair is on fire. You know, to Stephen's point, a lot of Title IX coordinators are not legally trained, yet we are asking them to really act like lawyers in very emotional cases. So it's a very, very difficult job. So, you know, appreciate them. So now I wanted to just turn it over. Another area of concern in the administrative area is accreditation, and what we might see in terms of changes in the accreditation process as a result of the Loper-Bright decision, and also maybe as a result of the changing in an administration. So Brian is an expert in this area, so I'm going to turn it over to him. And by starting with explaining to me in particular, and maybe some other folks out here, you know, where do accrediting agencies get their authority from to start with? And, you know, how will they be implicated by this change in administrative law?
Good morning. Can you hear me okay? Great. Good morning. First, let me thank Provost Salkin as well for the invitation to come and participate. You can see from where I work, I came from San Francisco, so it's a long ways, but Touro has a very soft spot in my heart because I've worked with Touro University, particularly medical students in accrediting, helping to get them accredited and maintaining their accreditation over the years. So thank you to Provost Salkin and to President Kadish, who I've had the pleasure to work with during that time. Accreditation, let me ask, with respect to the audience, as an extension of the earlier question, how many of the attorneys or even the law students here work in the accreditation space? Okay, so it's the minority of the audience. For those of you who do this, I appreciate any comments later on during the question and answer, anything that I have to say. But accrediting agencies receive their authority to regulate higher education from fundamentally under the Higher Education Act, then through a recognition process by the Department of Education and an advisory committee to the department called the NACICI, which is an acronym. Let me see if I can remember it correctly. National Advisory Council, Integrity and Quality Assurance Council, Quality and Integrity. It's supposed to spell out NACIQI, NACICI, made up of deans, educators, a couple students on the committee who make their recommendation based on an extensive review by the department in post-education, post-secondary education division of the Department of Education. It's an application process and in its basic form under Title 34 here for Part 602. With respect to Loper Bright, at first, when I read Loper Bright, my hair caught on fire because my relationship to Chevron dates back to when it was first decided in 1984, when I was sitting in administrative law. It's a very important course for the law students. I read Chevron in 1984, and as a practicing lawyer, as a trial lawyer, and later as a judge, I relied on the Chevron principle consistently. And during all that time, I felt secure that if I simply said Chevron deference, people knew what it meant, and there the case went away, substantial evidence, you know. But then when I read Loper Bright, immediately my bedrock foundation in the practice of administrative law crumbled apart. But then I went back and read it and reread it and read some other literature having to do with Loper Bright, and my hair started to grow back. And it's for this reason. Under Chevron, it is a statutory construction issue. When it comes to accreditation, the judges have to reach below the statute into the standard. Now, does that mean that Loper Bright doesn't apply in the accreditation space? Absolutely not, because in one of the cases that I cited in outline that was presented to you, professional montage, that's a case that's frequently cited in accreditation cases, along with Thomas Poole, because those courts relied on the Chevron principles of analysis. But Chevron and Loper Bright both speak to statutory construction, not to interpreting accreditation standards. Accreditation standards are those that they're basically regulations the accrediting agencies develop. And most accrediting agencies, if not all, must follow a certain process like administrative rulemaking. But what I've found, and admittedly it's in a limited sense, having worked with programmatic accrediting, is that the rulemaking process isn't as formal as an APA 706 rulemaking. That is notice and comments, publish the comments, present the data analyses and the evidentiary support for the rulemaking itself and the responses that go with it. Many of the accrediting agencies are short on professional staff as well as consultative expert staff provide that kind of data analytical support for the rulemaking. Much of it comes from anecdotal practice by the accrediting commissioners themselves. For example, and I'm going to give you this example because this is where I worked. The Commission on Osteopathic College Accreditation, COCA, accredits all of the osteopathic medical schools in the United States, including Touro. All of the standards have to deal with, are required under the regulations and the Higher Education Act. And both the regulations and the statute require certain kinds of standards to demonstrate rigor, the quality of education. But there are some standards that aren't required to be included under the Higher Education Act or the regulation. So could a judge say that this standard is arbitrary and capricious? Absolutely. Because if you go under the professional massage case, the district court case decision was completely overturned by the Fourth Circuit. The Fourth Circuit actually criticized district court judge. And this is where Professor Lake's comment about the federal court being a gatekeeper is particularly important. I think under Loper Bright, that district court judge's decision might be affirmed, even though it's a clear substitution of judgment case. But there could be a reversal of these kinds of cases or certain overreach by federal district court judges, thinking that not only can they interpret the statute, beyond that, they can then interpret the level of the standards for both programmatic accreditors and regional accreditors, like your middle states commission that accredits for university. So there is that potential danger. Now, there isn't that much litigation occurring in the accreditation space because there has been this deference to accreditors. But also, it's an area of the law that most people don't get into by the number of hands that you saw go out. But it's also an area of the law when you talk about accreditation law in the higher education space. There's a certain, when I first encountered it, I'll tell you my personal reaction. There was a fear of the unknown. But if you know if you know administrative law, accreditation law becomes easy. Matter of fact, but frankly, there isn't much litigation to be seen, and so that's why the professional massage, Chicago Auto and Transmission, Thomas Cooley, those are the cases that the courts have relied on. I think Loper Bright might actually have a different impact.
Thank you. I've also heard rumblings on the political front that some Republicans in particular take issue with, from almost an antitrust perspective of, the accreditors are often the leaders at a competing institution. And is that fair? Should there be some more independent body that accredits colleges and universities and law schools and medical schools, et cetera? What are your thoughts on that, given the change in the administration?
So there have been some rumblings. Originally under the Sherman, the antitrust law, it was thought that nonprofit organizations, particularly in the higher education space, are exempt or immune from suit under the Sherman Act. But there have been a couple of cases that have said to the contrary, have permitted actions to proceed against higher education institutions. One involving Brown University and another involving the ACGME, the residency folks that accredit residency training programs. As a result, there have been some rumblings and threats of challenge, but nothing significant so far. But a case that's not related to higher education, but clearly could is a case called North Carolina Dental Board against a Federal Trade Commission. That was a case that started out in North Carolina. The North Carolina Dental Board, a state agency, whose board members were elected by the Dental Association, which is a private nonprofit. But once elected, those individuals are then appointed by the state. They wanted to prevent teeth whitening folks from doing that work in the malls and so on, claiming that teeth whitening is a practice of dentistry. The teeth whitening industry took that case to the Federal Trade Commission and claimed that it was a violation of the antitrust laws, and the FTC agreed and enjoined the dental board from enjoining teeth whitening folks. The case then went to the Fourth Circuit. Fourth Circuit's analysis was this: on the 11th Amendment challenge, immunity challenge, which is for the law students, the alter ego. 11th Amendment says that if you are a state agency, you enjoy the alter ego of the states or an immunity. So North Carolina said dental board can't be sued. Case must be dismissed as an alter ego of the state. Fourth Circuit said that no. You are an alter ego of the state if you enjoy all of the indices of governmental status. But when you have board members who are elected by a private organization, and most importantly for FTC purposes, board members who are market participants, have a competing interest in the function of the industry, and you no longer enjoy alter ego status. Now, what does that have to do with accreditation? Alter ego, not at all. It's the principle of market participants. So I see some heads shaking yet, nodding yes. You know where I'm going. All accrediting agencies, whether it's SACS, Middle States, whether it's COCA, LCME, all accrediting agencies are staffed at the decision-making level by deans, presidents, educators, and students who are market participants. Now, how does this get back to Sherman Act? Where the Sherman Act originally said nonprofits, and in particular higher education space, nonprofits like accrediting agencies are not subject to jurisdiction of the Sherman Act. Guess what? Now they are. Because accrediting actions, state lines, they involve exorbitant fees. For example, the COCA charges $106,000 for an initial application to become medical school, and then more fees on top of that thereafter. These are substantial dollars that are involved in accreditation. And so the courts have said that this is a commercial activity, even though it's by a nonprofit organization. So if a challenge occurs that accrediting agencies, particularly at the programmatic level, are involved, decisions are made by market participants. Here's an example. The COCA regulates 69 medical school campuses owned by, I believe, about 45, 46 medical schools. COCA is a commission of 19 members. You've got a third of the number of medical schools being regulated by, all of the medical schools being regulated by a third of those deans and professors in that industry. The competing forces by market participants is very high. So antitrust is an issue that's looming out there, particularly with judges who might see themselves emboldened by, say, Lieberman, from a different context, of course, nonetheless emboldened. You might see some activism there.
And I just want to say, when I was at general counsel at one of the universities, I was involved in an antitrust case. So the judge didn't get the memo that higher ed was exempt. He entertained the case. So let me just say that. So thank you, Brian. I wanted to obviously get to Matthew, who is going to talk to us about an area that's really been quite active in terms of shifting regulatory standards, particularly under the Biden administration with respect to student loan forgiveness, the wonderfully well thought out FAFSA update that went so well. And some other areas of financial aid that might be impacted by both Loper Bright and the changing administration. So Matthew, take it away.
Thank you. First, I want to thank Philip Falcon and the Touro Law Review for having me here. So when I first started in higher education, someone told me higher education is one of the most heavily regulated industries in the country. And they said, and I would even argue that the only one that's regulated more is nuclear waste and nuclear energy. And I am seeing that every day, day in and day out, with all the new rules and regulations that are changing as we go forward. Now, under Title IV, every school is governed under a program participation agreement with the Department of Education. That lays out all the responsibilities of the higher education institution and what we need to do to comply to maintain our federal funding. Now, for most, if not all, higher education institutions, Title IV funding is paramount. Without Title IV funding, you have less students and won't be able to continue in that realm. Now, what we've seen in this higher education Title IV area is a lot of administrative red tape ported to the institutions. Now, we spoke about Title IX and how Title IX gave the institutions the burden of basically litigating sexual assault cases without any assistance. And we're also talking about how there's a lot of non-lawyers dealing in these processes. Now, with Title IV, more so, there's not many lawyers handling the Title IV area. It's not something that just happens or a lawyer says, oh, I'm coming out of law school and I'm going into Title IV. It's, as a attorney working for a higher education institution, happens because you have to maintain that eligibility, and that is one of the most important things you can do. So we have a couple of regulations that really affect how institutions operate. One of the most, I guess, the most open of those wounds is gainful employment fair financial value transparency, which was actually due at 11:59 last night after multiple delays. And why I bring that up is because this was laid, it was enacted, it was delayed again. There was a lot of comments, a lot of issues with how this was enacted and what this meant. Now, what is this? It's essentially gainful employment is for any non-degree programs or for-profit degree programs, right? How are your students leaving here gainfully employed, and what does that mean, right? Are you giving them an opportunity to better themselves through this option, right? And is it better than, I think the standard is a high school degree, right? Is this better than a high school degree? Are you spending the federal funds to better yourself in that way? And financial value transparency applies to all programs, degree programs included. And that basically says, well, when your students graduate, how are they succeeding financially in relation to their loan? And we just spoke about lawyers going out of law school, or potential lawyers leaving law school and going into other fields. So, right, how does that affect this calculation, which they're taking directly from the IRS, right? Schools are submitting this data to the Department of Education at 11:59 last night, and the Department of Education at some point is going to cross-reference that data with the IRS data and determine that, well, your students aren't progressing the way they should, or they're not making as much money as they could be. They're incurring from your programs. And what is happening with higher education institutions is I've been dealing with this for weeks and months with our internal personnel trying to pull the data, give the Department of Education data from years and years ago, clearinghouse data, right? Was it corrected? Were the SIP codes changed at a certain point? Because they all were, and that created discrepancies in the data. There was actually a notification, I think it came around 9:10 at night last night from the Department of Education, that essentially said, hey, we know you're getting a lot of errors as you submit all of these files. But as long as it's submitted by 11:59 tonight, don't worry, you could fix the data later. So what does that mean? How long are we going to have to be going through this process? And in the new administration, will they even be utilizing this data? Because we know that President Trump previously delayed the gainful employment rule, and now we don't know what this is gonna mean. This is a great information gathering session for the Department of Education, but what will happen to the higher education institutions that submitted this data? And what if there are errors? What if there are students who were not correctly classified? What does that mean? Will that trigger review by the department? Will that not? What does that mean? And again, we're seeing that the department has well intentions, right? They're trying to say, hey, we want to make sure that schools are educating students, that these students are better off than they were before they went into those institutions. But as an institution of higher education, right, that's our goal. Our goal is to educate students. Now, what the students do with that degree and what they learn during that time is on the student. The student has the responsibility of going to class, taking those exams, devoting the time to those studies. And what they do with those degrees, should that be purported to the institution that is offering them. So that's something that we'll have to wait and see. And then we got into the FAFSA issue, which it was enacted 3 years ago. The FAFSAs typically come out on October 1st, and the schools start getting the batches and they're able to process them as they go. First time it was done, I believe we had to wait until January to get the first batch from the department, and that had errors and issues, and I think they recalled it, and I got calls every day from our directors, and I don't know what to do. How do I process? Like, I've already put this in our system. How do I pull it back? What do I, right? And the answer was no one knows, because the department is learning just as we're learning about these errors. And this is happening in real time. I think last year it was, they did a little better. It was in December that we got the first batch. And I think President Biden last night signed into law that he will have a deadline of October 1st for all FAFSAs going forward. Now we'll see what happens with that. But again, it's important for institutions to process these FAFSAs, because students who are applying to your schools want to know what they're eligible for. What are they getting, right? And that may dictate what school they go to. And then we get into a whole nother issue of, right, we're talking about students receiving the aid, the students taking their courses, and then you have a whole nother sector of borrower defense claims and public service loan forgiveness. Now, President Biden, when he came in, he was, I think, promising 20,000 or 10,000 for every student in loan forgiveness, which obviously was shot down. And then there was, I think, one or two more other proposals for loan forgiveness that were shot down, but they delayed, and there was different mechanisms for students to delay their payments and prevent payments. I think Cardona yesterday or 2 days ago said that no student went into default under his term. I think that was the line that he used, which if anyone knows about repaying loans and students, I don't know how that's possible without some help. And with borrower defense, you have a mechanism for students to claim that years ago, at some point in time, they were deceived by their school and that they're not getting the benefit of the degree that they earned. I think one of I think this is being reviewed by the Supreme Court now. They said that they're going to take this up later this year. But one of the things that's at issue is one of the defenses that the students can use was material misrepresentation at the time of their enrollment. And when I saw this, and there was a couple of cases where you're getting a claim from 1992, a student sending a letter saying, hey, I met with this person at this day, and he gave me a pamphlet, which I can't find because it's all paper, that said, you have to register right now or else your spot is going to be taken. And that student now is one, operating in that field successfully. Two, has been operating in that field for probably 20 years now, but they saw this mechanism where, hey, I can get my loans discharged. If I can get my loans discharged, I'm going to try to get my loans discharged. And so you have schools having to respond to those claims with very limited information. You're talking about claim, right? Let's say there's a 5-year document retention policy in place, or 5 years, 7 years. Those documents are nowhere to be found, and we're not obligated to have them. So how do you dispute a claim from that far away when you don't have any evidence to support it? And many of the people they're citing are either no longer here, retired, or far gone.
Yes.
And it's just, as an institution of higher education, these are all the things that we are dealing with on a day-to-day basis. And as in-house counsel, I have to advise my principals, right? What is our plan on this? Who is going to do this, and who is equipped to do this? Because, right, the financial aid counselor doesn't know how to advise a student on the legal ramifications of these things or what it means in the future. And so as in-house, we have to make sure that we know how to train these personnel, but also retrain these personnel as these regulations change over and over and over and over again. And that's, I think, one of the biggest challenges as in-house counsel with this changing regulatory landscape, is making sure that everyone knows what the rules are and what rule of law we're operating on. Title IX is a primary example, right? What date is the right date? Is it August 2020? Is it 2024? Is it 2011? Right? And I will say this because it's a public website. Touro's Title IX website, we actually have date ranges for every policy, and said, if this matter occurred between this date and this date, please use this policy. If it occurred between this date and this date, please use this policy. Because there's no other way at this point. There's no other way for us to adequately inform everyone. We try to do it in orientation. We try to tell students, but we all know that everyone listens at orientation all the time and knows all the information. But that's the way that we found was the best to get the information out in a clear and concise way, so that someone who is a complainant or is a respondent knows where to go
Knows what the rules are.
and knows what the rules
That
are.
would be helpful. And I've thought of this, what happens with a continuing violation? So there's a sexual assault under, the Biden regs, and then there's another assault involving the same parties under the Trump regulations. Like, what do you do? Under what guidance would you? How are these poor Title IX coordinators supposed to know? And how are the students supposed to know their rights and responsibilities? It's crazy time.
That's a huge point too, because students matter in this process too. They are young adults trying to navigate new experiences, trying to deal with a lot of policies and paperwork. And what courts are typically doing, for example, in the contract realm, is the standard is, what is the reasonable expectation that the student? That's another layer in the interpretive analysis. Not only what we, but what would be the reasonable interpretation of a student trying to decipher all.
Okay, so I'm just going to check, where are we on time? Do we have time for questions? Okay, so I wanted to throw it open to all of you to see if you have questions. Raise your hands and we'll send somebody out with a mic.
Well, thanks to the informative presentations. A question related to accreditation. The incoming administration has indicated that they may weaponize accreditation, use it to accomplish political objectives in pushing back against woke higher education as they see it. How might that unfold? What process would they have to follow? What do you think the risks are?
Well, so I'm sure everyone's here seen tension between accreditors and both Congress and state legislature. Congress, on the one hand, with the Republican majority, is looking to tighten the accrediting process even further. But what they have to overcome is under the Higher Education Act, it says specifically nothing in this chapter that is under the law is construed to permit the secretary to establish criteria for accrediting agencies or associations that are not required by this section. So there is no limitation that's imposed under the statute. So that, I think, is somewhat of a bar. I'm not going to say a high bar, but somewhat of a bar to Congress in making those kinds of changes in view of the tension that exists. Now, what does that mean? In Florida, what you saw was the state legislature act to prohibit DEI, for example, in their state institutions, and also flowing into some of the private institutions. And that's where the accreditors and law intersect. Accreditors now have to comply where both the statute and the regulations and recognition processes are silent on whether or not DEI should be a standard. But we all know that that's a good thing for accrediting standards across the nation, include DEI as a part of quality of education that's delivered. Where a state legislature prohibits it, accreditors are now running afoul, and that's one of the outcomes of that is regional accreditation, for example, where for example, Touro had to be accredited by middle states. Now those boundaries are gone. It can be accredited by WASC, it can be accredited by HLC, and so on, depending on what's most favorable to your needs as an institution. I'm not sure that I've answered your question. I'm not sure that there is an answer to that question, but I think that tension is going to be more visible and will become tighter with other. And accrediting agencies are likely to tread more carefully.
Remember the first, so thank you. Just to follow up. Do you see the threat to programmatic accreditation the same? Will it be different? Is that a reasonable question to ask?
That's a perfectly reasonable question to ask, and I think it's a great question because the focus has been on regional accreditors. Congress, let me say this rather loosely, I don't think Congress understands the difference between regional and programmatic accreditors. And so programmatic accreditors are somewhat insulated from all of the things that are going on to the extent that the overarching issues are at issue. Now programmatic accreditors also are looking at, again, I'm going to go back to DEI. That's a big topic of discussion in the accreditation field. Every accreditor seems to include a DEI standard. Where both Congress and the state legislatures are prohibiting it or somehow limiting it. As to the regional accreditors, that flows down to programmatic accreditors.
Right in front of you, no.
Thank you. I'm Nora Deem Leitner. I'm the president of St. John's College, a relatively small liberal arts college with not pretty standard, I think, for this size college, not an inside in the House Counsel. I think one of the things that we're seeing, and Peter was alluding to this in his comments, is an incredibly active state legislature in Maryland. And what we're now seeing is lots of questionable relationships between federal and state law, not in the Title IX realm, although I suspect we'll start seeing that in that too, but we're now seeing it with data privacy laws. So not even specific to higher ed, but really covering higher ed. So I'd be curious to hear from you. A, is this a trend you see continuing? And B, what's your best counsel to small schools in these kind of situations? Because I'm in charge of controlling risk for my institution, and I want to tell the board that I do my best at this. So I'd love to hear from you what you recommend.
Is it addressed to me? Here, let's.
So I think you just have to be in touch with your outside counsel if you don't have a general counsel's office. But I think that you need to be able to understand how all of these regulations intertwine, right? What is the state requiring in these specific situations? What is the federal government requiring, right? How does that interact? What does that mean for your school one way versus the other? And what are the intersections that you can, right, eliminate from your analysis? But I think that states have their own rules. Title IX, I know New York State has their 129 requirements as well as their Title IX requirements, right? So you have that you're following the rules as they are. There may, in many cases, just be a need for two different policies. One that's a federal requirement, like Title IX, versus one that's a state mandated policy like 129B, and make sure that you are applying them in equitable situations when they are necessary.
And that's just going to hop on your point, a little less technical in my answer. There's another aspect of being a higher ed lawyer that we all have to respect, which is reputational risk. And a lot of this grappling of what do we do? How do we do it? Do we want to be the front runner in finding the answer? What I tell my clients every day is let's not chicken little this to death, okay? You all bring a lot of experience, insight, acumen to the table. Our job as lawyers, whether it's to the legislature or to the judges, to explain why you do it, how you do it, why it makes sense, okay? So I hear your plight and I understand it, but I tell my clients this daily, don't feel defenseless because you all bring a lot more to the table than that judge who's dealing with the case, okay? So protect your institution, do what you think is best, consult with your legal process or legal counsel. I do think the simple answer is it has to be the whole, and reputational aspects of justice.
Brian wants to say
5 seconds. NACUA is a great resource for GCs. That's my plug for NACUA. I find every day the thread that I see in my inbox, really a piece of it.
Incredible. You're allowed to have a question.
So just this for Brian, but really for any. So the specialized editors and with different states that have taken different approaches where specialized accreditors in particular can't maybe enforce that part of one or more of their standards. Do they have to change their standards globally, or are they allowed to have different standards that are allowed to have the regulation applied differently to different schools in different states depending upon what their states are mandating?
That's a really germane question. For those of you who don't know, I was once the president of a university myself with a medical school, and attending President's Council with an accreditor, that very question came up because some of the schools were in Florida and in the South, other schools in states with different requirements. And at that time, this might have been about 2 or 3 years ago, at that time, the discussion really was around, could the accreditor put some pressure on legislatures of their own states? And while the accreditor was optimistic, and we all know how that story ended or is ending. So the bottom line answer to your question, Dr. Salkin, is I don't know, but I don't think the accreditors have the upper hand at the moment because of the climate in the legislatures as well as in the voting population that are supporting the legislature.
You know, I was just curious because a lot of accreditors are giving citations for some things that's irrelevant in some states. And so if it's relevant if your state hasn't outlawed it, so to speak, do you still have to comply when other schools don't? And it's the same set of rules for all schools.
Right. Yeah. The accreditors have their own self-interest in their recognition, because if they don't issue the citation, uphold the citation and go through with it, their recognition process gets affected later on when they're before the Department of Education. That's where the transformation at Department of Education is important. Are they going to enforce their own regulations under Part 602 as to the enforcement of standards? So it could be circular that way, but I think accreditors really are vulnerable at the moment for those reasons.
I just want to thank the members of my panel for working with me, and to thank Provost Salkin for organizing this panel. And thank you.